All right, everybody. Thank you for joining us this evening. I'm thrilled to introduce everyone to Paul O'Brien. If you have not met him before, Paul is actually a past board member for the Down Syndrome Association of Delaware, and graciously, every 6 months or so, does a webinar for me at my request when I get a ton of questions from families about the different topics that he's able to assist a lot of folks with. Paul and his father's practice is always our top referral for any legal needs of DSA families in terms of long-term planning. But he and his father truly have the most expertise in Delaware, I would say, and really know how to work with our families that have individuals with Down syndrome specifically. I know a lot of you have asked me for his contact information, and I have shared it. So hopefully this webinar will give you a little bit more intel on how he may be able to assist you and just in general what things to start thinking about as your children get older and you begin all the fun complications of legal planning. But I will go ahead and turn it over to Paul. We are recording this webinar, and I will share both the recording and Paul's information with anyone that's registered for the call as well, so you can reach out to him directly if you have questions. In my experience, he's more than willing to help folks as he's able. But thanks again, Paul, for taking time on your busy schedule to do this, and I'll go ahead and turn it over to you.
Okay. Well, Lauren, thank you so much for having me. I really appreciate you coordinating all of this. And I've worked with a lot of families at the DSA. And as Lauren mentioned, I was a prior board member myself. So this is a community that I feel pretty enmeshed in, and I'm proud to serve. So I kind of give you the big global picture version of this. When we do this kind of planning for our clients, there are always a few documents that work together. And the real star of the show here is a document called a revocable trust. So a trust at base is just a written set of instructions for dealing with someone's property. And in that way, it's kind of like a will. Will's another written set of instructions for dealing with property. But the kind of shortcoming of a will is that it could only start working if you had died. And 9 times out of 10, my clients, they're going to need help from other family members or friends at some point before they die. It's not saying it doesn't happen, but it is the rare case where a client of mine just all of a sudden keels over and doesn't need any help from anyone. The more typical case is that we're going to need other people positioned to do things for us, to pay bills for us, to advocate at doctor's appointments, file tax returns, all these jobs that we look to these documents to achieve. But the trust is the centerpiece, at least when it comes to dealing with financial matters. And trusts we found to be a lot more useful than alternatives to them, like powers of attorney. And powers of attorney, we do, and for all of our clients, and they're an important part of it, but where powers of attorney are not particularly effective is at banks. The banking community has grown pretty hostile to powers of attorney for understandable reason. A banker looking at some old power of attorney from 2025 has no way to corroborate whether it's still good or not. And the usual scenario is some well-meaning relative walking into the client's branch, waving a power of attorney around like it's gospel. And we often find that the bankers reject it, that they'll say some version of no. So when bankers are dealing with a trustee of a trust, they tend to be a lot more comfortable because the law is different and the optics and logistics to it all are very different. So legally, bankers have zero obligation to police trustees in the same way they'd have to police an agent under power of attorney. So the statute governing powers of attorney says You bankers, by accepting this power of attorney, have accepted the role of denying it if you think it's being abused later on. Well, I don't know what abuse looks like. Who made the cash withdrawal? How the money was used? I have no idea as the banker. But what I do know is if I get that angry phone call from my customer, my job is on the line. So they will often find new and creative ways of saying no. But with the trust, they're off the hook. And there's the kind of optics and logistics difference to it. With powers of attorney, they're only usually coming out in the middle of some crisis when you're unable to corroborate whether you still want them in place or not. That's the whole point. You're laid up in the hospital, you're not picking up your cell phone, you can't okay it with the banker, and the bankers will freeze up. But with a revocable trust, you're able to get more proactive than you ever could have with the power of attorney. You take the trust agreement, the revocable trust agreement, to the banks, to the financial advisors or insurance companies, wherever you have your money, and retitle your existing accounts to the trust. So that way, the banks have it directly from the customer in advance of that crisis, that the people you pick as trustees, they're okay to work with. And if they do something that they shouldn't be doing, well, the bank's pretty comfortable about that too, because the banker's position is going to be, hey, we didn't force you to put your accounts into this trust. You signed every piece of paper to do it. We didn't pick your trustees, you did. You hunt these relatives down and get your money back, but we don't need to get involved, which means you need to trust the people you put in that position. But a bit more on that later.
Paul, can I interrupt you real quick?
Sure.
So I guess a lot of people come to me and ask, what age of my child should I be doing this? What timeline would you suggest to folks in terms of setting up this trust? Would it be anytime that they have kids? Is it when their kids reach a certain age? And how would this affect their situation if they had, for example, a teenager with Down syndrome or a young child with Down syndrome as well?
So good question. My kind of barometer to this is really, do you own real estate? Do you own a home? Or do you have children, regardless of their age? You should be doing this because we don't get to control the timing of the accident. That's in the man upstairs hands. So I think we're always doing this with an eye to get proactive, to get ahead of the problem. So I think as soon as you have kids, you should really be doing this. And, a lot of people will go out and they'll buy, big insurance policies to prepare for that. But along with doing that, you need to have some structure for the money too. And I think it's all kind of part of the same process of planning, of financial planning and legal planning too. So the trusts we use for really three big jobs. And the first is bill payment, if you weren't up for it on your own. And then the other is to avoid probate, which can be a really expensive nightmare for families. This probate process happens when people die and property passes through their wills, or they die without wills, and it leads to the same outcome. The Register of Wills will, at least in Newcastle County and every other county in Delaware, collect some user's fee at the end of this based on the net personal estate, whatever the person died with. Here in Newcastle County, it's 2%. So if your bank accounts and brokerage accounts and life insurance, they pass through probate, that can be a really expensive mistake. So we want to make sure those things get into your trust. And there's no benefit to the family in probate. Right? It is a system that has been pretty conspicuously designed by and for dead people's creditors to make sure that Visa and MasterCard and funeral directors, they've all been paid before any other family members walk off with any money. And it's a really tedious process too. You have to explain to the penny everything that the deceased had on date of death. You can't just say, well, my late father's brokerage account with $20,000 worth of stocks in it. That's not going to work. You got to itemize each position explain the high and the low of that stock, and come up with the average. And all of it's being done for the benefit of creditors. So had that same account been owned by a revocable trust prior to death, there's no probate, no 2%, no interface with the register of wills, none of those pesky lawyers' fees. It tends to be a lot cheaper to do everything privately in a trust. And the other big reason why we use trusts is to help protect kids. And this applies equally to those with disabilities of some kind and those without. And typically for my DSA families, we'd be doing what's called a third-party special needs trust. So that trust would usually only be funded upon that parent's death. And the instruction in that trust would be, well, take care of this kid of mine, pay for things for him or her, but don't pay for things that Medicaid or some other state, federal, county program is already paying for. This should supplement those benefits, not replace them. So if that kind of language is included, whatever that child would have inherited from mom or dad is not tripping them up from Medicaid eligibility. And you're cut off from Medicaid if you have more than $2,000 in available assets. Medicaid's position would be, well, you have to spend all of mom and dad's money first before we, provide any services for you. So if it's in a special needs trust, then the trustees of it can dole out the money for the benefit of that kid, can pay for things for them, but they also preserve that really important Medicaid eligibility. And that same kind of dynamic of protecting kids can apply to those without disabilities, without Medicaid issue. And if you have other kids or other beneficiaries you'd want to leave money to, they can continue to keep whatever they've inherited from mom and dad in a trust share that they would be able to control, at least at some given age. And you can set what that age is, as young as 18. I usually wouldn't go too much past 30 because no one wants to have to babysit a 30-year-old with what they perceive as their own money. So with this style of trust, that or typical kid can be sole trustee of it, can get all the income from it, and has another important power called the power of appointment. So that's the kid's ability to dictate in writing where they want the balance of this, the unspent balance, to go when that kid dies one day. So it's an important way to empower that beneficiary to be able to more finely tailor mom and dad's rough outline of a plan around their future family's needs. So that's an important tool. And also importantly, that kid can spend money. They can invade the principal. But we hold the slightest bit back. We say, kid, you can only spend mom and dad's money for your own needs related to health, education, maintenance, or support, which is a very broad, very pliable standard. But by including it, if that son or daughter is ever sued or divorced or going through a bankruptcy, they can very conveniently and very honestly tell a judge, Your Honor, that's not my money. It looks a lot like my money because I'm in total control of it. I get all the income from it. I can see where the balance goes when I die. I can spend it, but mom and dad said I could only spend it for me, not the needs of anyone else. So that's an important protection that draws people from all over the country to sign trusts here in Delaware. And that's a protection you don't get in most other states. Or in order to get it, you'd need to have some third party, like a bank trust department, serve as trustee at pretty significant administrative expense. But if you come to Delaware to sign, we don't need the middleman in the way.
Paul, we have a question in the chat.
Yeah.
I have a special needs trust. How do I go about funding that? I had it written up, but I really have no clue what it entails.
Okay, so typically if it's a special needs trust that was created by the parent, That would only usually be funded upon death, and that funding should happen through either a trust or maybe a will. A will would be an expensive way to fund it because it means probate to
Mhm.
get from the deceased's personal name to the special needs trust.
So
Um,
if folks have an existing special needs trust, that could be accounted for within a revocable trust that they could create with
correct.
the team or with someone else. And then something that I was unaware of that folks might not be clear about too is within the revocable trust, you could include a letter to a judge stating who would potentially have custody of your children as well, correct? That is part or could be part of the revocable trust, or how does custody go about upon death of both parents too?
Sure, good question, and it's one that's raised by a lot of families with young kids. And my advice to my clients is, don't attempt to do this in a will or a trust, but rather a letter written in that parent's own language, not legalese, explaining to a judge who that parent thinks would be a good decision for a guardian. And we parents, and I'm the father of two young girls myself. We want to have that kind of assurance that we get to control who the guardian would be. And the truth of it is that we don't. We don't get to make those kinds of calls. A judge decides. And I kind of take solace in that because, some of these writings go out of date pretty quickly. If you include some clause in a will or a trust saying, if I've died, my guardian of my child will be, my brother Bob. Well, what if Bob's moved to California? What if Bob's in jail? There are all these things that can happen, and a judge is there to see how mom and dad's wishes comport with reality at the time the decision is being made. And I've noticed over the years that judges don't really like being bossed around by living people, much less dead people. And a clause in a will or a trust that purports to command a judge where their son or daughter is going to go is not very persuasive. So, and it's kind of a very rigid way to try to persuade the judge. I think a better approach is, again, a letter that you could easily amend, you can update, you can shred it. And in that letter, you can provide persuasive reasoning to a judge. Your Honor, I think my brother Bob would be a great choice because he's financially stable. He lives in the same area. We wouldn't have to uproot these kids. He has kids about the same age. We go to the same church or synagogue or mosque or whatever it might be. And you can go on and on about those reasons. And then a judge is there to look at this letter and say, all right, well, how does this mesh with reality now? 15 years after this letter was signed. And reality might be very, very different. And at a certain point, at least for more typical kids, the judges are instructed to listen to the kid. As young as 14, they're able to kind of self-advocate. Obviously, it'd be different if when you're dealing with someone with Down syndrome, but that's the judge's instruction. So one of the reasons I gravitate towards trusts is that they're very reliable tools to provide checks and balances in a guardianship. The guardian, absent a trust, would be in total control of that kid's money. And little kids are not asking hard questions about how their money is being spent. But if you have a trust, you can have multiple people, not just one, looking at the money and figuring out what's going on, making sure that mom and dad's instructions are followed. And if there's a deviation, it could be found out.
So, Paul, with a trust and the trustees that are named, they essentially
Mhm.
work as a team for the joint support of the individuals that the trust is supporting, correct? And who do you typically
Yeah.
see listed as trustees, is that typically family members or friends, or kind of, I'm sure folks are kind of thinking
Mhm.
who they would potentially list, if you could go into a little more detail about that too.
Sure. Yeah. Great prompt. So, yeah, often it is family. There's no rule saying that it needs to be family. I have plenty of clients who, don't use family for their trustees or agents. They use friends that they know and respect very well. And my or our advice on that subject of picking trustees or picking agents has evolved over the years. And my current advice to all of my clients is don't just pick one person who is just as mortal as you. Hopefully, you have a few. And there's no perfect number. But if you have two, you've doubled the odds that someone is going to be there to follow your rules. Got three, you tripled it. Four, all the better. I would concede, at when you get to 9, 10, 11, that might be too many people coming out of the clown car. But, I think uh, 2 to 5 or 6, that's fine. And I think another bit of advice I always give my clients is don't attempt to rank these people, as I so often see in these kinds of documents. I'm a big advocate here for a flat organizational structure. So the usual setup would be, mom and dad are the trustees for right now, and as far as the eye can see, we're paying our own bills just fine. We don't need anyone's help. But if one or more of these 2, 3, 4, 5 people think that we need help, it is likely because we need help. The job we're asking these folks to do is not a glamorous one. It's, paying Comcast and other utilities for us. It's not fun. So if you let these people self-select when they think it's time to help, you've created a much more flexible, much less confrontational system, as I see in some other styles of planning, where the aim kind of seems to be to make it harder for people to help. The kind of traditional model to doing this planning, I don't think works very well. And that would have the parent kind of tier out people in a family, right? If it's my trust we're talking about, obviously I trust myself the most. I'm my own trustee. And then I suppose I trust my wife over here, but only if something really bad has happened to me. Only if I'm dead or incompetent on the say so of 2 doctors, then we could pass the baton to her and she could be the trustee. But if she's dead or incompetent, then the oldest kid or the tallest kid, and you keep going down the ranks. Who wants to be mom or dad's bronze choice if you had 3 kids? It doesn't sit particularly well. And I think what that system is doing is selling a maybe comforting but really false illusion of control. Like, I get to decide decades in advance which of my relatives and in what order will be best positioned to help me. Uh, People don't get those kinds of calls. Right? The man upstairs decides that, and your choice number one could be in worse shape than you are at the time you really need help. But you're too far gone to change the trust. And, how's choice number two going to get to choice number one's medical records to prove that they're incompetent? They can't. We have HIPAA now. So just structurally, I don't think it really works. But if you have a flat structure, you haven't ranked people. We've successfully planned for attrition. We're not predicting who's going to be best. So maybe first in your lineup, they're able to do it, great. But if they're not, we got other people who are also equally positioned to do the job without having to prove death or incapacity. And I think the other big advantage to that is that it's frankly a more protective system to the client than the tiered system.
And it's more of a
Yeah,
more of a team collaboration, right? Like they're working in the
it can
best
be.
interest.
Yeah, I mean, often it is the case that one of the people on the lists runs point, right? No one's, your family members are not tripping all over each other to do this job. Usually they talk with each other and say, well, nose goes or whatever system they
Sure.
come up with. Rock, paper, scissors, shoot. Who wants to do the job? And they pick a point person, but I think it's helpful for that point person to know from the outset there are 2 or 3 or 4 other pairs of eyeballs who could also look in and see what you're doing. You're
Mhm.
not operating in a vacuum. And we have had the unfortunate experience of seeing otherwise good, reputable people talk themselves into some pretty bad decisions when they think there's no possibility of being found out. I don't know, if Dad only knew what a jam I was in, he would have lent me this money. And after his stroke, he's not asking very hard questions about how it's being spent. So I'll just borrow a little bit, maybe $20,000, and I'll repay it eventually at a better interest rate than that stingy bank could ever pay. And none of my siblings or, or other potential trustees need to know about it because I'm choice number one, and I'm neither dead nor incompetent. I'm a highly competent borrower.
Sure.
So if you knew from the outset there's a few other pairs of eyeballs who could also walk in and get a statement from the bank, you're a lot less likely to talk yourself into that kind of stuff, and you're a lot more likely to be found out. So I think the transparency that flat structure creates is a really helpful thing to families.
So, Paul, for the revocable, so if someone is hearing this and they say, we do not currently have a revocable trust or any sort of will in place and we need to establish one, they would contact your office. And then
Mhm.
what, I guess a lot of folks ask me, well, how long is that process? What would I need to do in order to set up
Mhm.
a revocable trust? Can you kind of go into some of the documents that they would need to gather in order for that to be compiled? I think a lot of those logistical questions are asked when I chat with
Sure.
people
Yeah.
about it.
Well, that shouldn't be a barrier because there's not that much that I need.
Okay.
I don't need bank account numbers. I don't need social security numbers from trustees. I don't need their birth dates. The fundamental question is, who do you trust, right? And hopefully you've done some thinking about that, and you have 2 or 3 or 4 names of people who you could lean on for bill payment and talking with doctors. That's the primary homework assignment. But I don't need to go gathering financial data, and because and that kind of it touches on another very common misconception about this. The trusts, at least a well-designed trust, should never mention any of the assets that it might own, right? Because the assets that a client owns are changing by the millisecond. Sometimes, if you're in a money market fund, those stocks are being traded in fractions of a second. So it's kind of it's a fool's errand to try to compile all that stuff. For financial advisors, I think that makes sense, and you need to do that. But for estate planners like me, we don't need to get that far into the weeds. And particularly now that we have a very, very generous federal estate tax exemption, it's $30 million for a married couple, $15 million for an individual. So if you had someone who had that fortunate problem of teetering around those numbers, maybe we would need more detailed financial data. But for the vast majority of us mortals, we don't need to get that far into the weeds. I see another question that came in. If you are talking about a revocable trust for the special needs or for ourselves. So it's both. So the revocable trust is used for the parents. So the main jobs of revocable trust are making sure that parent's bills are paid if they're not well enough to pay those bills on their own, and then avoid probate, and then fund that special needs trust after the parent's death, along with perhaps other funding other trusts for other kids if there are any. I hope that helped answer your question.
So, Paul, I guess maybe it might help to clarify too, a special needs trust, some folks might not have those established on the call.
Mhm.
How does that differ and when do you recommend that being established too?
Well, the special needs trust I touched on a little bit. The instruction in that trust to the trustee would be pay for things for this son or daughter with a disability, but don't pay for things that Medicaid would otherwise pay for. It should supplement those benefits, not replace them. So that's really it. I mean, it's not a hyper complicated document. And you might go on to say, well, when that son or daughter of mine eventually dies, the money remaining in this trust, if there is any, should return to my other beneficiaries. So that you can do because it's a third-party trust. It's mom and dad's money funding it. It's not the kid's money, right? If it's that son or daughter's money, the son or daughter with a disability, there needs to be what's called a payback provision for Medicaid. So any balance remaining when that kid dies would go back to Medicaid to reimburse it for what Medicaid's shelled out for that kid's behalf. But here, when you're dealing with a third-party trust, mom and dad can reroute the money after that kid's death to other relatives or friends, or do whatever they'd like to do with it. I see another question that came in. What kind of account is it when a child has a bank account and you want to save for its child?
I think what this person is referring to is a lot of families are eligible for certain benefits, but if you have
Mhm.
assets under of a certain amount, then you're
Mhm.
not eligible for different programs. And maybe getting into
Abe,
like ABLE accounts. That's what I
yeah,
first
yeah.
thought.
So I think you're probably referring to Able, and so Able came along a few years ago, and that was created under Section 529 of the IRS code, and that 529 is the same section of code creates college savings funds. So parents and grandparents can stock money away for that kid's education. It can grow income tax free over the years, and provided it's spent on a qualified educational expense, there's no penalty. If it were spent for, tickets to the Taylor Swift concert, then you're going to be paying a 10% penalty on the growth. But you're capped to what you can put in each year, and the money can grow, and you use it for education. The same thing, the same section of the IRS code allows for savings funds for people with disabilities, and that's called an ABLE account. And in Delaware, dependable is the office of the treasurer that creates and kind of governs these things. And it's the same kind of idea. The parents or the kid with a disability themselves can put money in there, and you're capped at $19,000 per year. That's our gift tax exemption. Although I learned that over the summer, Congress changed the rules and they expanded ABLE, so you can contribute even more to it. It's the lesser of whatever that uh, uh, person with a disability made in income, or their federal poverty limit in that state. The only kind of caveat to that is that the person with a disability could not have contributed or received money from a IRA or other retirement plan. Awesome. Lauren just sent the link about ABLE. So it can contribute, the money can grow, and provided it's used for a qualified healthcare expense, then there's no penalty. And qualified healthcare expense means, practically speaking, anything you could imagine. I mean, very broad parameters for spending money for that kid. Looks like another question popped in. Use the trust name. I'm not sure about that. I might need to follow up with that question a little bit later, and get some more clarification there.
Yeah, and I mean, when you do establish the trust, you do rename your accounts under the trust name, correct, Paul? Maybe that's what they're
Correct.
referring to.
Right. So you retitle
Yep.
existing accounts to your revocable trust. And then when you've died, that revocable trust becomes irrevocable because that parent died. And then it funds the special needs trust. Does that help answer? I hope so.
And I will just say too, I mean, everyone's situation is different and everybody has different questions in relation to their family dynamics and et cetera, et cetera. So when you set up a meeting with Paul, he'll be able to go into more specifics too about what he recommends for your situation.
Yeah, we try to do it. You kind of alluded to it earlier. What do we need to prepare? What does the logistics look like? I try to keep it simple, and I try to do it in 2 meetings. And the first is I block off about 2 hours to talk through all these documents, explain them, figure out what the client wants to do, what the goals are. And then at the end of that, we quote a fee to do the work. We do everything on a flat fee. So we don't charge people by the hour. But I want to know, how complicated of a job is it? But I can say typically it's somewhere between $2,000 and $3,000 to do the whole shoot and match. So revocable trust, either two of them for husband and wife or a joint revocable trust, wills, and again, that the fee would be the same for an individual or a married couple. Powers of attorney, I do 2 sets, one for financial matters, another one for medical matters, and then a living will or living wills for a married couple that describe intention for end of life care. And then usually a deed to transfer any real estate that client might own to their trust. So we do that first meeting. I quote the fee, and at which point the clients are free to say yay or nay. And if they want to shop it around more, that's fine by me. They don't owe us anything. But if they want to proceed, we'd usually ask for half the fee at that time, and then the other half of typically about a month thereafter, when we get together and review and sign all the documents. But included in that is the client's unlimited ability to ask questions of us. So again, we never charge by the hour, and we really encourage questions from our clients. Confused clients are bad for business. I want the opportunity to unconfuse them and make sure they understand the work product and how to use it effectively. So that's how we work. Other
If
questions?
anybody has other questions, you feel free to unmute
Yeah.
yourself or put it in the chat and we can read it either or.
Yeah. Okay. So we should also, I mentioned living wills a little bit earlier, and it's really not a fun topic of conversation, but a living will is a document that describes intention for end of life care, and we try to do this in a way that is intentionally vague and flexible. We'd say if I'm in one of these 3 sad conditions described by Delaware law, and I can't communicate on my own anymore, family members, doctors, you don't need to do things to me that will merely prolong my dying process. So if it could make me feel better, that's fine. If it buys time for other relatives or friends to fly in, that's okay. But if all it's going to do is stretch out suffering, I don't need that. And that's applied in these 3 scenarios. I'm terminal, means I'm going to die in 6 months or less, or permanently unconscious, coma for 4 weeks. 2 doctors agree I'm not coming out. Or this third one, I'm seriously ill or frail, which says 2 doctors would not be surprised if I died within the year. So we try to keep it flexible and keep it simple. Let's see. Looks like another question popped in.
Yeah, Paul, it's about guardianship, and
Mhm.
we do get this question a lot. I did put a
Sure.
link to the webinar that you did for us that I referenced quite a bit,
Mhm.
but if you could briefly go into that, I think it would be helpful.
Yeah.
Because I do frequently hear the assumption of we need guardianship,
Mm-hmm.
um, and not understanding the difference as well. Um, yes, and then there's a question too saying I'm a grandparent of an adult with Down syndrome and I have a revocable trust. How do I leave money to his special needs trust within that revocable trust?
Okay. Well, I'll handle the second question first because that's pretty straightforward. You need to include a clause that identifies that trust and what percentage of your assets you'd like to leave to it. And I would always recommend that the parent, rather than the grandparent, usually create that trust because the hope is the natural order of life prevails, and your child is going to have a longer horizon than you do. So if they need to adjust course, if they need to change things, there's more opportunity to do that rather than grandmom and grandpa setting up the special needs trust. Although you could, I think it's better to have the parent do that. There are exceptions to every rule, but that's usually my take. And then there's a question as to guardianship and powers of attorney. And we did this webinar. Was it earlier in the year or was it last year? Um, Relatively recently. And it's a question that pops up all the time, and people assume that they need to be guardian for their son or daughter with Down syndrome, and they don't. The guardianship is a pretty nuclear option in most cases. It's a really extreme thing. A former justice of our Supreme Court wrote that guardianship is about the most restrictive thing the judicial system can impose on another human being outside of incarceration. That's pretty heavy. It's depriving that son or daughter of the ability to do things on their own. And I think the ambition for most parents is to allow their kids to gain some level of self-reliance. And guardianship really cuts against that. It's taking away those rights. I think the better solution in most cases is powers of attorney. Usually the son or daughter with Down syndrome doesn't have all that much of their own assets to be taken advantage of. Might have a little bank account here or there, maybe social security check, but not a lot of their own money. So the idea of using guardianship to stop designing people from financially abusing that son or daughter with guardianship, I think is kind of silly. There's not much there to begin with, and it's a very difficult thing to change. And I won't mention any names, but and maybe some families are familiar, but I had a call that I will never forget back in 2020, peak COVID. Longtime client of ours he had bad news. He had a pretty advanced cancer diagnosis and called me in a panic. Paul, we need to get into court. I need to change this guardianship. I have this cancer diagnosis, and the doctors are telling me I have weeks to months left, and we need to do this now. Look, in a normal setting, you're a few weeks out. We're in peak COVID. The court system has been backed up. There's nothing we can really do about it right now. And I would have really wanted to tell him, it's okay. We can sign new powers of attorney. Had he not gone that guardianship route, we could very quickly and very cheaply change the documents to allow other people to help his daughter. So he had that kind of assurance before he passed, but I couldn't. So I think powers of attorney are much more flexible. You can change them. They're much more cost effective. Guardianships, when you're into court time, you're into thousands of dollars there, and the process is pretty onerous. A guardian ad litem is selected by the judge, who goes out and sees whether this person with a purported disability is disabled enough to warrant guardianship. And if so, is this guardian who's petitioning, are they the appropriate person to take on the job? And then the guardian ad litem is charging, the attorney who's pushing this through is charging. And where does it get you? I suppose in some cases it's needed. Not all disabilities are as apparent to the naked eye as Down syndrome. We get a lot of people with pretty profound mental illness, untreated bipolar disorder and schizophrenia. That might be a good case to go through with guardianship because you don't know what they're going to do. They might change their minds all of a sudden and really start being a danger to themselves or others. But I've noticed that most of my clients with Down syndrome, they know they need help and they're amenable to the help, and they want their mom and dad to be part of the helping team. And signing powers of attorney is a good way to do that. And you can change it so that, maybe siblings or cousins or other aunts and uncles could also be in a position to help that son or daughter with Down syndrome. So I think it's more flexible, it's cheaper. I mean, we typically charge like $200 for powers of attorney as opposed to thousands of dollars. And I'm not sure exactly how this message was spread. I kind of get the sense that it was from school administrators who keep harping on it. And they don't really need to. They're protected when they're dealing with powers of attorney, but I guess they feel safer when they have a judge's order that they can look at and make sure that they can completely take the parent's word for everything. But that comes at significant cost and inflexibility. So this is a few years ago, but the judges on our chancery court in a bench and bar conference made it pretty clear with us trust and estates lawyers, if guardianship isn't absolutely necessary, don't pursue it. Don't waste our time when there are less restrictive means like powers of attorney to enable other people to help this kid with a disability. And I listened to that. I think they were right on. And I think powers of attorney are a really good thing. And guardianship, well, we need it every now and then, should not be the first line of defense. Other questions? Well, the other thing that kind of came to mind, and actually it's in that webinar, the earlier webinar, is the supportive decision-making statute. And Alex McFassel was on that call, and she was one of the co-architects of that. And the idea there, I think, was well-intentioned rebranding of powers of attorney. And I think there's a ongoing misconception in the public about what powers of attorney are. And it's not depriving other people, it's not depriving that son or daughter of their ability to do things like a guardianship would. I often will talk with prospective clients, will say, well, I'm power of attorney over my son, or I'm power of attorney over my father. No, you're not. No, they could change that in a blink of an eye, flick of a pen. They could revoke it, right? You're not imposing your authority on anyone else. They have allowed you to help, and they can very quickly take that power away. So this kind of supportive decision-making statute, I think, tried to whitewash a little bit of that. And it's really contractual in nature. What kind of decisions can this person make with a disability make independently? What kind of decisions will I allow my mother or father to provide input on? But in any event, you have to be there with them. And I think it really effectively confused the target audience, which is, bankers who are worried about what's going on in accounts, and doctors who are worried about their own liability. Can I take mom or dad's word for it? Or, where are the lines here? The document, the supportive decision-making statute, I think really blurred those lines, well-intentioned, but I don't think is super effective. Looks like another question popped in. So a guardian isn't needed when the parents have died? Question mark. Depends how old the kid is, right? If they're over 18, guardianship is not needed. If they're under 18, then you need a guardian. And then we go through that same kind of analysis. There needs to be a hearing, and a judge is asking the question, what's in the best interest of this kid? And they're guided by what the parents wrote and what the facts on the ground are. And they sort through all those facts and come up with a decision. What other questions do we have? Or I hope that answered the question. Lauren, do you have anything?
No, I think that was a clear answer. That I understood that. Yes, does anybody else have any questions for the chat?
Okay. Yeah, can I just talk instead?
Sure, yeah, Marilyn, that's easier. Go ahead.
Okay. Yeah, so I'm just kind of confused because then, so if, theoretically the parents pass away before the special needs individual, and then the trustees that are then responsible for the special needs trust are making all the decisions for that individual. I just feel like there's a gap there.
So the trustees are not authorized to tell that person where they're going to live, or can control their movement. They're in charge of the money. The trustees are in charge of doling out the money for the kid's benefit.
So Marilyn, the person with Down syndrome still has autonomy over their decision-making process, right? They're acting as an adult in terms of making their day-to-day decisions, but they don't have control over the financial aspect of it, right, Paul?
Right.
Okay, right. So I guess, so let's say the parents have passed away and the individual is still living with those parents. What about living arrangement decisions? Who makes those if there's no guardian named?
Well, usually the trustees can talk with the person with Down syndrome and say, hey, this seems like a good living arrangement. We will pay for it. And that usually is persuasion enough. You don't need to force it. If the person with Down syndrome says, no, I'm not living there. I'm living, I'm moving across the country and living with my girlfriend. And that seems like a risky proposition to the trustees. They could always go into court and get a guardianship. But my point is, it shouldn't be the first thing that they do, right? There's usually no reason to do it unless the person with Down syndrome is really acting wildly. They don't want any help, and they're not really listening.
So you're saying the trustees would have the ability to then request guardianship? That's within the power that they have as trustees?
Well, it's not within the power, just as individuals.
It's an option. Marilyn, how I've heard it best explained too is typically guardianship is not necessary if the person with Down syndrome is typically open to hearing feedback or suggestions from others, and typically not super against an adult giving them advice or something like that. You know what I mean? That I
Yeah.
would say for the large majority of our population, it does work as a great option and avoids dealing with guardianship, which is complicated both legally and financially, because they trust and know the trustees that are advising them on financial matters, which really affect a lot of everyday life.
Right. And I
Okay.
mean, there's the power of the pocketbook, right? I mean, hey, you
Yeah.
want to go to this group home, okay, but this is where we're going to spend our money. So, all you might get is a social security check, which isn't going to be enough to pay the bills at where you want to live. So I think that there's kind of an organic decision-making process that happens there without having to go through guardianship. So
Okay. Can I keep asking questions? I don't
yeah,
want to
Yes,
get in the
yep,
way of
yep, go
anybody
ahead.
else. So when the special needs trust is set up, especially if the child is young, um, right at first, I guess it's typically the parents and perhaps not a few other people that are the trustees.
Mhm.
How easy now, as the child ages and the parents get closer to end of life, I'll call it,
Mhm.
well, how easy is it to change the trustees on that special needs trust?
Pretty easy. You can amend all the documents that I've talked about, and they're living documents. They're meant to be looked at. I tell my clients at least married couples, every 5 years or so, take a look at it and make sure the people on
Mhm.
this list are still the people that you want. And if we need to change it, we can change it.
Okay. As it, if you are getting to those older years, you know, I'm just trying to figure how, I know I've talked to some people who have put it in the hands of some, um, I don't know, state organizations to be the trustee. Does that exist? Not sure if a state, if that's the
Well,
right way
kind
to
of.
term
Yeah,
it.
there's every state in the union. And let me just, before I lose the thought, I will answer that question. But when I build these documents, I would always go on to say that this group of people, they could be trustees, but they could also pick other trustees. So if there's only one family member left who could have done the job and they get some bad diagnosis, there's something that happened, at least they could punt and hand the job off to someone.
Mhm.
And that someone else might very well be one of these state organizations. So every state in the union has something called a pooled fund, POOLED, and the pooled fund in Delaware is Delaware Care Plan, and they will serve as trustees of special needs trusts. So I always include that as an option for the trustees within the special needs trust I design to hand whatever remaining balance there might be over to Delaware Care Plan, and they can administer it. And it's a great organization. Overhead is very low. I think they're like three full-time employees. Ellen Bachman is an absolute rock star. She runs that show,
Hmm.
and she'll dole out money and coordinate with family members and teachers, social workers, and other stakeholders, figure out what bills for this person need to be paid, and then pay them. And what they do is they'll pool together, pretty big tranches of money. So the minimum account size is $5,000. So you get someone with $5,000 and someone who walks in with $5 million, and they put all the money together. And then they go out and they buy pretty vanilla investments, like Vanguard Index Fund, Vanguard Income Fund, and you're given your tranche based on what you walked in with, and that tranche is going to grow as the market grows, and it's spent on the needs of that person with a disability. And then if it's the parents or some third party's money that goes into it, and that person with Down syndrome has died, any money remaining goes back wherever that original funder says it should go.
It does.
They also serve a really important role in administering first party trusts. I get a lot of those kids who've been plaintiffs in some lawsuit, and they've received money from some injury, and it would otherwise disqualify them from Medicaid. If they win, well, it doesn't really look a lot like winning when they get kicked out of the group home because they have more than $2,000. So Delaware Care Plan will take those proceeds and invest them, use it for that person with a disability. But the catch with those kinds of arrangements with a first party trust is that any balance remaining needs to go back to Medicaid to pay for, to reimburse Medicaid for what it's spent over the years. So it's a great organization. I think they have a lot going for them, and it's an important option to just be aware of.
Okay, I was under the impression that some of these organizations, maybe this one, that whatever residual was left when the special needs individual dies, that it stays with the state. That's not true.
Depends what the source of the money is. So if it's a third party trust, then it goes back to wherever that third party donor said it should go to.
Okay.
So mom and dad's money going in, mom and dad get to call the shots with how the money's going to be spent. And then when that kid dies, it goes back wherever they want it to go. If it's a first party trust, if it's the kid's money that goes into it, that's a very different arrangement. There it needs to go back to Medicaid.
Medicaid.
Right.
But not to Delaware Care Plan, or
no.
they don't keep anybody's money. Okay.
No.
Okay. I just feel like that choice of trustee is the most difficult part, you know.
It can be. It's something that really you need to put some thought to. But as my younger sister is so fond of telling my mother when we're out to dinner, not making a decision is a decision, Mom. Just pick the appetizer. You know, so you gotta kind of commit to a choice at some point. And there are no perfect choices here, but I think my clients are much better off when they have a few, and there are no particular qualifications. You know, you don't need to be a lawyer. You don't need to be an accountant or some, financial guru. You need to be a trustworthy person. And not to be, glib about it, but if it's someone you can trust with a key to your home, you can probably trust them to be a trustee. If you're confident that your TV is still going to be there when you come back from vacation, they've passed a pretty big litmus test. So if you have a few of those people, I think you're much better served. You can trust them, any one of those people, all the more when they could look in and see what the others are doing. Does that make sense?
Thank you very much. Yeah. Thank you.
Any other questions from the group? Well, thank you all so much for your time. I really appreciate it. I will follow up with everyone who's registered and on this now with both Paul's contact information as well as the recording. I will also put a link to the 2 past webinars Paul has done for us. So if you'd like to reference those, but I really encourage you to shoot Paul an email or give him a call if you have further questions or if you need to get these things set up. His team makes the process very easy to follow, and I trust him with all of our DSA family, so highly recommend.
Could I?
Go ahead, Marilyn. Yep, go ahead. Oh, I think you're muted.
just wanted to mention that Evan, my son Evan Seward, is here with me, so he didn't log on separately. You didn't
Okay.
realize that he was part of this, but we've been watching this together, so.
Okay,
Thank you.
great. I will make sure Evan gets the copy too. That sounds
Great,
good.
thanks.
Thank you.
All right. Well, thank you everybody for being on. And Paul, thank you so
Yeah.
much for your time. I really appreciate it. I know it's a busy time of evening for everyone, but it's better than during the workday for folks. So just reach out to me if anyone has any direct questions and I'll connect you with Paul. But thanks everybody again and have a great night.
Okay. Thank you so much, Lauren.
Thank you, Paul.
Thank you.